Welcome up everyone. It's fantastic to have you all here today for our National Road Safety Partnership Program webinar called Transition to the New Chain of Responsibility, Are You Complying? This webinar is proudly brought to you by the NRSPP in partnership with the Australian Road Research Board and Holding Redlich. Next slide, thanks Geoff. My name is Rosemary Patterson and I'll be your co-moderator this session. I'm here to provide tech support if required and field questions. Next slide, thanks. I'm joined by Jerome Carslake, who manages the NRSPP and its many activities. Welcome, Jerome.
Thank you, Rosemary.
And for anyone joining us for the first time, could you tell us a little more about the NRSPP and its purpose?
Certainly, my pleasure. The NRSPP has been established to provide a collaborative network for Australian businesses and organisations to help them create a positive road safety culture, both internally and externally. It aims to help organisations of all sizes across all sectors that share and build road safety initiatives specific to their own workplace and beyond. It is delivered by ARB and funded primarily by Government Coalition and ARB. So for more information and more tools like this webinar, please refer to the NRSPP website. And I know this will be a great webinar knowing Geoff and how COR is a hot topic. So looking forward to it.
Fantastic, thank you. Next slide, thanks Geoff. Before we start, we'd like to show those who are new to webinars how to have a quick look at the webinar tools, and today's webinar will go for approximately 60 minutes with question time included. If we get more questions than we can answer, we will be able to respond by email. We'll be recording the session and we'll share the recording. Next slide, thanks Geoff. Webinars work best when they're interactive, so please feel free to ask any questions or share your experiences along the way. You can type them into the questions box there you see on your screen. If you experience any technical glitches, please use the raise your hand function and we'll be able to assist you. Now the best part, it's my absolute pleasure to welcome Geoff Farnsworth to the studio today. Geoff is one of Australia's leading transport and commodities lawyers with 25 years experience in the field. He's been recognised in Chambers Asia Pacific for providing strategic and effective legal advice, and has been listed in Best Lawyers in Australia as a leading lawyer in the categories Shipping and Maritime Law and Trade Law since 2013, and editor for the COR Advisor publication. So welcome Geoff, and you're not in the studio, you're interstate. Welcome.
Oh, thank you, Rosemary, and thank you everyone for dialing in to participate in this webinar. It's a great pleasure to be here and hopefully get a chance to answer some of your questions and give you a bit of background, or I guess an introduction, some things to think about for the changes that are coming down the line to the what we all know as the chain of responsibility by virtue of these amendments to the heavy vehicle national law. Most of you will know, if you've been reading the COR Advisor publication, you will have already got some good information about it, but you'll be aware that the law is changing, COR is changing. As far as we know at the moment, those changes will probably come into effect around the middle of next year. So that means that really for the next year or so, you've both got to keep your eye out in respect of compliance with the law as it currently stands, and also start thinking about what you need to do in respect of compliance with the changes when they come into force around the middle of next year. So the purpose of this webinar really is to outline the changes that are coming, share some thoughts with you at this stage about what you might want to do about compliance, and answer any questions that you may have as a result of anything that I have to say this afternoon. So leaping right into it, I guess the changes are, I think, quite significant. The changes have been broadly described, I suppose, as being for the benefit of the industry, in that some felt that the current law was too prescriptive in relation to prohibiting, expressly prohibiting certain activities. The defence, or the only defence that was available, was the all reasonable steps defence, which some of you will be familiar with. That was considered to be a very high bar. It was a very high bar to satisfy. So that has changed. The onus of proof has changed. It's now on the regulator to prove, or the prosecutor, to prove the breaches, rather than the respondents to prove that they didn't commit any breaches. There's a bunch of new concepts, like the primary duty, which are important. I think one of the most significant differences, though, and we can talk about this as we go on, is the effect that this is likely to have on executive officers of corporations. And I think it really puts them in the crosshairs now in a way that they never were before. That includes the potential for jail time in respect of certain breaches. And I actually think that if I sort of look back over the last couple of years, there probably have been incidents which, if they were to happen after the law changes, could result in directors of companies and executive officers going to jail. But we'll talk about that a little bit more. So if you see the slide on the screen there, that's the summary. It's this concept of primary duties. It echoes the work health and safety law and the rail safety national law. And that primary duty is to, so far as reasonably practicable, to ensure the safety of transport activities carried out by the organisation. As I mentioned before, executive officers are now required to exercise due diligence to ensure that transport operations are compliant with the legislation. And executive officers may now be convicted even if the company has not been prosecuted. The other significant change is that the penalties have gone up. An individual, in addition to getting a criminal conviction, can be liable to a fine of between $50,000 and $300,000 and or 5 years imprisonment in extreme circumstances. And corporations, the fine has commensurately increased from to $500,000 to $3 million. So, you know, the regulator is sending a very clear message. I think that we've had basically 10 years to get used to this concept of the chain of responsibility. I am still constantly surprised by how many people still don't have their head around the chain of responsibility, or are even aware that there is such a thing and that they should be complying with it. People who really should know after the course of 10 years. And these aren't people who are necessarily bad and avoiding the legislation. They just genuinely don't know about it, and they don't know that it applies to what they do. And I suppose the changes that are coming down now are really stepping up the potential, the penalties. And it really is, we're now sort of in the stage where there are no excuses, I think, for non-compliance. The nature of the offences and the obligations has changed, as I mentioned in the introduction. So the four, mass loading, fatigue and speeding, have changed from a must not obligation to now a positive must ensure obligation. That's going to have, or potentially that will have, an impact on compliance and policies. What sort of policies do you need to have in place, and what documentation do you need to be able to produce to prove to the regulator that you have ensured that you've done all of these things? The reasonable defence, the all reasonable steps defence, as I mentioned, has been swept away, and we are now left with the unless reasonable excuse defence, the onus being on the prosecution. So that's just by way of introduction and summary. Are there any, I know it's early on, but are there any questions that anyone has at this early stage?
So I've got a question for you. We had quite a lot of rumbling a couple of years ago about maintenance. Where does that sort of land in the new chain of responsibility?
Maintenance, if we have a look at what the obligations in relation to transport activities are, and transport activities are defined as activities including business practices and making decisions associated with the use of a heavy vehicle on a road, including, for example, and it lists a number of things that are required as part of transport activities. Maintenance isn't expressly included in that list, but it could easily be, it could easily fall within, at a higher level, one of the obligations within that list, I think.
Okay. And I saw you had individuals and corporations, different sort of scales of penalties in there. Where does a subcontractor sit in there?
Well, a subcontractor, do you mean the person or the corporation?
Well, I guess in some cases, say you're, a small or medium operator, and maybe you've got 10 trucks or 8 trucks. What sort of scale, what sort of risk is there to those? Should they actually be penalised?
Well, if you're sort of alluding to the question about, I suppose, business practices and also what is necessary, I suppose, in terms of demonstrating that you've taken all steps that are reasonably practicable, the last element of that, the reasonably practicable sort of definition in the Act, includes as one of the considerations the cost associated with the available ways to be compliant, including whether the cost is grossly disproportionate to the likelihood of the risk or damage. So in deciding what is reasonably practicable in relation to a particular duty, there will be an element of considering, toll might have a higher standard, for example, than a smaller subcontractor, which I suppose is slightly awkward in some respects, because that's a bit of a trade-off in that you should, as a road user, expect all vehicles to be equally safe. You shouldn't necessarily expect that toll vehicles are safer than any other vehicle. I suppose it just sets the bar at a certain point, and it requires individuals to do as much as they can reasonably, do whatever is reasonably practicable in their circumstances.
And I guess I've got a question here. How will the changes affect the consignors, from Chris?
Well, the consignors will continue. I mean, the consignors are still parties in the chain of responsibility. How about I press on, and
yep.
Maybe Chris's question will be answered, and if it hasn't been answered by the end, I can come back and sort of go into that in a little bit more detail.
Excellent. Let's get into it.
So I wanted to just sort of talk about the message of the regulator and what I think the regulator is doing in relation to these amendments to the chain of responsibility. And I really think that they are saying that it's up to the board and the executive of a corporation to set out, to define the company's corporate culture in relation to safety, to the extent that if there is a breach of that corporate culture, you can't necessarily hide behind the corporate veil, as we call it. You really are finding that you are, as an individual, significantly exposed and will be responsible if you can't demonstrate that you have exercised your own due diligence, I suppose, to set the culture, to set the safety culture of a company. It imposes a positive obligation on directors. One of the new, I suppose, the new principles that is introduced into the Act expressly is Section 26A of the new legislation, which sets out the principle of shared responsibility. And it may well be that as you look at that principle of shared responsibility, you assume that it means shared along the chain of responsibility, or the supply chain, as it were, horizontally. But it's equally, I think, saying that it's a shared responsibility between corporations and individuals in a way that it wasn't expressly before. And what the executive of a company is now required to be able to demonstrate when the regulator comes knocking is that they have exercised due diligence. And that is defined helpfully, or it's an inclusive definition of due diligence at Section 26D(1)(3). And it's worth just looking at those things because it requires that you take reasonable steps to acquire and keep up to date knowledge about the safe conduct of transport activities, to gain an understanding of the nature of the legal entity's transport activities. And if I can just pause there, if you're a smaller company and you are involved in transport, you're a transport business, you would expect that most of the people on the board would have a relatively good grasp of transport activities, because that's the nature of your business. But to come back to Chris's question about, well, how is this going to impact on consignors and consignees, transport might be a peripheral aspect of what they do. They might be a retailer, for example. So they might be really focused on branding, real estate, leasing properties, or doing whatever. They don't necessarily, they may not necessarily see transport activities as being part of their core business, but they need to now, I suppose, is the change that this brings about. And as a sidebar to that, there is this continuing issue about, well, how much information does a board get, and how much information does a board need about the company's transport operations? The effect of these amendments really escalate that quite substantially, I think. So it requires the executives of the company to be able to demonstrate that they have gained an understanding of the nature of the legal entity's transport activities and the hazards and risks, including the public risk associated with those activities. They must ensure that the legal entity has and uses appropriate resources to eliminate or minimise those hazards and risks, and to ensure that the legal entity has and implements processes to eliminate or minimise those hazards or risks, for receiving, considering and responding in a timely way to information about those hazards and risks and any incidents, and for complying with the legal entity's duty under Section 26C, which is that primary duty of care that I mentioned. One of the issues that I've written about recently and sort of thinking about how this is all going to play out in practice is a situation where you may have an executive officer, you may have the transport or logistics manager of the business who is not satisfied with the amount of resources he or she is being given by the company to comply with his or her or the company's chain of responsibility obligations. Given that that person is now exposed to quite serious potential penalties, what are they to do? How do they raise that with the corporation? One of the sections that I just mentioned required that there be that there must be processes for receiving, considering and responding in a timely way to information about those hazards. So it raises the question of whether companies need to have some sort of whistleblower protection, I think, for their executives. So, or any employee who might be concerned about safety aspects of the company's transport operations. Anyway, these are the sorts of issues I think that we're just really sort of working our way through how this is going to apply. And it is, I suppose, why yes, it's 12 months, I suppose, until this is going to come into force around the country. But it is really something that we need to start thinking about now. And just going back to my slide, the other thing that you're going to have to be able to do, or a company is going to have to be able to do, is prove that it actually went through these processes. Largely, I suppose, a risk analysis. So someone sat down, they've conducted a risk analysis of the company. Where are the potential exposures in relation to the chain of responsibility, and what is being done about that? And if you can't produce that evidence when asked, it's going to be very difficult to prove that you've complied or that you've exercised the due diligence that's required. So I might come back to that a little bit later on, but I think that reinforces to me that the regulator sees that it is the job of the executives of businesses to take the lead and be responsible for building that corporate culture of safety and attention to the chain of responsibility obligations within the company. The other changes, the more specific changes, we've got mass dimension and loading. The current responsibilities, as I mentioned at the very beginning, were prescriptive. There was a prohibition on doing certain things, subject to being able to satisfy that all reasonable steps had been taken. That has been changed to the primary duty obligation. So instead of the all reasonable steps defence, the parties must ensure that the vehicle complies unless the person has a reasonable excuse. The other aspect, which is fatigue, current responsibilities, driver duties. A person must not drive while a fatigue-regulated heavy vehicle on a road while the person is fatigued, and then other parties in the chain are responsible for taking all reasonable steps to ensure that a person does not drive the vehicle on a road. The fines there, as you can see, are relatively paltry by comparison to the fines that are now coming down the line. So from the commencement of the new law, driver duties and penalties are unchanged, except the reasonable steps defence is omitted. There is no defence for a driver's breach of fatigue duties. Party in the chain duties omitted. Obligation of parties in the chain to prevent fatigue offences is now covered only by the new section 26E. And there are various amendments to the work diary requirements. Speeding was dealt with under Chapter 5 of the current law. It imposes duties and penalties on parties in the chain of responsibility to ensure that speed limits are not exceeded. Chapter 5, speeding is omitted, and all speeding provisions and offences are now covered by the primary duty provisions that I've been talking about in sections 26C and 26E. The duties of each party in the chain of responsibility, as we've mentioned, there were separate offences and separate penalties for mass dimension, loading, speed and fatigue, covered by the all reasonable steps defence. We've now got the new section 26C, which is the primary duty section, and that requires each party, so far as is reasonably practicable, to eliminate and minimise public risks and not directly or indirectly cause or encourage a driver or other COR party to contravene the heavy vehicle national law or exceed a speed limit. Each party in the chain of responsibility must ensure, so far as is reasonably practicable, the safety of the party's transport activities. such as contracting a person to drive or maintain, repair the vehicle, packing and loading goods, receiving unloaded goods, etc., etc. And then in relation to penalties, we've had a look at those already. So do any have any questions in relation to what I've just been through?
Oh, we do indeed. We do indeed. So first question here, and I guess this is probably just a bit of context. Arthur's asking, are there specifications on what size vehicles this chain of responsibility applies to?
Well, it's so far as I'm aware, it's not changed from the definition of heavy vehicle as applied under the previous law. So it hasn't got any bigger and it hasn't got any smaller.
Excellent. How will this affect freight brokers by Ash?
That's a good question. Well, it depends on whether freight brokers fall within, whether they can be said to fall within the chain of responsibility. Are they a scheduler, for example? Arguably, they might be, but they're a fairly, I suppose, intrinsic, part of or member of the chain of responsibility. The only other thing I suppose that they could be, well, they're not really a consignor or a consignee. Look, if they were, if they could be defined fall within the definition of a scheduler, then yes, they probably would be within the chain of responsibility. But the difficulty, I suppose, is that, well, no, I suppose schedulers are the same. Schedulers aren't necessarily party to the actual transport contract itself, the movement of the goods from A to B, but then neither are schedulers. So look, I mean, if I was advising a freight broker, I'd say, look, you may well be captured. You probably are. It feels like you should be in some respects. Why wouldn't you? At the very least, you probably have some influence over the terms of the contracts that are being entered into, and you've still got an obligation, I think, probably to make sure that those contracts contain appropriate provisions in relation to speed, mass and fatigue and that sort of thing. So if I was a prudent and cautious broker, I would be making sure that I had some form of compliance program.
That's a great question. Got a good another two here. So Chris, I like a real world one like this one. We are an electrical construction company. We may order some cable from a supplier, and that supplier may engage a company to deliver that cable. How far down the line does the chain of responsibility go? As much of our operation is out of our control.
Well, could you just start that question again, Jerome?
Certainly. So we are an electrical construction company. We may order some cable from a supplier, and that supplier may engage a company to deliver that cable. How far down the line?
If I can just come back, it sounds to me like you're potentially a consignor. In that case, you may also be a loading manager if goods are being unloaded at premises that you operate. It is a good question, and it's a difficult one, particularly in relation to fatigue. What obligations do you have if deliveries, if heavy vehicles are coming to your sites or sites over which you've got some control, and those drivers are clearly affected by fatigue? That is probably that's probably the main area where you have an issue. You may have an issue with load securing as well, to make sure that as I mentioned, you may well be a loading manager, in that the goods are discharged at your premises or premises that you're operating or have some control over. So yeah, look, I understand that all you're doing is picking up. Well, here's another point. If you pick up the phone to order goods, and those goods are then delivered on a heavy vehicle, Arguably, and I'm not aware of any cases that have actually determined this sort of thing, you've got to have some sort of terms of consignment. Terms of consignment is a slightly nebulous concept which exists under the law at the moment. And what exactly are terms of consignment? Once again, if I was advising you on how to go about complying with your obligations under both the current law and certainly the law that's coming, I'd be suggesting that you have a policy, that you have a chain of responsibility policy, and that policy would need to be pushed out to your customers. You probably, and that would simply, well, that would be that you know, you expect your suppliers to be compliant with the heavy vehicle national law, and you reserve the right to sort of audit compliance if necessary. But possibly a more sort of serious concern is, as I say, what happens if a driver turns up at one of your sites and he's clearly affected by fatigue? What do you have an obligation to do anything in relation to that? And I suspect, particularly under the new chain of responsibility, you do. And you probably have an obligation to pick up the phone to your supplier and say, look, this guy that delivered the cables was, you know, out of it, or appeared to be fatigued, or whatever. So I think there is an obligation. There's certainly an obligation on the receiver of any goods these days, if they think that a driver appears to be fatigued. And I understand absolutely that's a very difficult thing to do. How do you, as an electrician, say, make a judgment about whether someone appears to be fatigued? That's something that you might have to have a look at. There is some guidance in the current version of the law about the appearance of fatigue, and it may well be that that's something that you are obliged and required to do. I hope that. I know it's a difficult scenario, because you do feel that a lot of these things are outside your control. But the fact is that consignors and consignees have obligations under the law, even if they are not the people who actually book the freight that moves the goods.
I guess the other question, just drawing on that, if you make that request because you're concerned about a driver, should you be following up as well to make sure that the supplier took action on that?
I would say it's a bit like the question that I'm often asked about audit. You know, okay, so you say we should be auditing compliance. How often do we have to audit compliance? And my answer to that is, well, if you audit it and you find non-compliance, you've got to audit it again. And you basically continue auditing it until you find that there is a state of compliance. And once you are satisfied that the people that you're dealing with, whether in your own organisation or your customers, are compliant, then you can maybe step back the compliance in audits to annually or semi-annually, whatever's appropriate for your business. So to come back to that question, Jerome, in particular, if you ring up your supplier and say, look, mate, you know, the bloke who delivered that cable, you know, he looked pretty sleepy to me, and I'm not, you know, we're next to a school and I don't want him running over any kids. If the guy on the other end of the phone takes that information seriously, I'd probably be satisfied with that. If the next driver who comes is similarly fatigued, I'd start to have an issue with that. Anyway, look, it's a question of, a lot of this is as much about evidence, being able to evidence that you've taken these steps. It's not just paperwork. It's not just sort of having a policy for policy's sake. If you have gone through this exercise, and if you have sort of done the risk analysis that I've described, and if there is an incident, you can produce that. You can say, well, we did the risk analysis. We're an electrical cabling business. We have to order these heavy vehicles. We have run this analysis. This is what we found. One of our biggest risks is heavy vehicles arriving on site with fatigued drivers and/or with the cables that inappropriately or inadequately secured. This is what we've done about it. we've got a policy, we push that out to our suppliers, and we expect them to comply with it. And so far, we're satisfied that they have been compliant.
Excellent. I must say, good questions, great answer. And just before we move on, I've got one good question here from Andrew, which relates to the section that we're in at the moment. In relation to section 26C, is a company liable if they do not adopt a new technology like IVMS?
Well, I think that comes down to they're not going to be liable because they haven't done it. They're going to be liable if they haven't even considered it. Or sorry, I'll take that back. They won't be liable if they haven't considered it. They're more likely to be liable if they haven't considered it. If they have considered it and said, look, at the moment we've only got a limited size fleet, it's too expensive, we'll do these other, we'll deal with it in another way, then I think you'd be fine. If you haven't even looked at it, if you haven't even run the risk analysis and looked at telematics, for example, as a method of managing some of these issues, then you're more likely to be in trouble, because it just suggests that you haven't exercised due diligence. It's fine if you exercise due diligence, make the inquiry, and decide not to do it for a perfectly good reason. But if you haven't even considered it, you're potentially exposed. And sorry, if I can take one, the footnote to that is, if you haven't even considered it or documented the fact that you've considered it, which is equally important.
Excellent. Thanks. We have another question, but I'll hold that over till the next question session.
Okay. Look, I spoke a little bit about the obligations of executive officers. I don't necessarily need to repeat what I said earlier on, other than to say I think if you take nothing else away from this webinar, the obligations and responsibilities on executive officers is going to change quite substantially, and you need to start thinking about a compliance framework for your executive officers. So that's it's sort of said. I discussed it earlier on. You'll see there on the slide that due diligence includes taking reasonable steps to know about the safe conduct of transport activities. And to use the example, sorry, I've forgotten the name of the guy who asked the question, but the electrical contractor. Yeah, that's a good example of someone who's they're not in the transport business. They rely on heavy vehicle transport, but they're not in the transport business. So in performing that sort of risk analysis, they have to think a little bit outside the box, and there may even be you don't know what you don't know. Is that the right phrase? But you may be surprised by what you find out when you run the risk analysis about the number of the interactions that you do have with heavy vehicle transport that could put you in the chain of responsibility and create an obligation on you under the chain of responsibility. The other point, obviously, is that the executive may be convicted, prosecuted and convicted even if the company has not been prosecuted. Anyway, look, as I say, if you take nothing else away from today, I think that's probably the most significant change that's coming. The maximum penalties, well, that's, I suppose, another relatively significant change that's coming. I did mention that there have been, I think, incidents in the last couple of years which could have seen individuals go to jail. There have been a couple of incidents in New South Wales in particular where people have been killed in heavy vehicle incidents, where I think there is a case where that an individual has been reckless in their attention to compliance with, or reckless non-compliance with chain of responsibility. And if RMS in New South Wales had the capacity to send people to jail, I suspect they would have given it a go. On that point, I suppose there is a compliance on the compliance or the enforcement piece generally. It has been, and I mentioned at the beginning that there's still there's a level of ignorance about the chain of responsibility which I find surprising. Possibly because I'm based in New South Wales, and the regulator in New South Wales, RMS, has been probably the most active in terms of enforcement of compliance. Other states haven't been quite so active in terms of compliance. I don't know whether that will change, but it's something to bear in mind. I think, most people, many heavy vehicle businesses that operate nationally, their vehicles are going to go through New South Wales at some point, largely. If you operate exclusively in Victoria, count yourself lucky from an enforcement point of view. But if you travel anywhere in New South Wales, then you've got to be extra careful about compliance. In relation to defences, I also mentioned at the beginning of this call that we had this thing called the all reasonable steps defence, which I know we've got 18 months or so to go, has never yet been, no one's ever yet made it. No one's ever succeeded on an all reasonable steps defence. Not that I'm aware of, sorry, I should add. There may have been cases that have slipped under the radar that I haven't noticed, but I'm not aware of anyone succeeding on an all reasonable steps defence. So that's not going to be missed by anyone, I suspect, in the industry. It's been replaced by the primary duty and the obligation to be able to demonstrate when asked that so far as is reasonably practicable, you have ensured the safety of the transport activities of your company. So that's a new way of framing it. It probably does make it harder for the regulator, for the prosecution. It means that they will probably make, not that they haven't been slow, but they'll probably make more use of their powers to issue notices requiring production of documents, so that they can establish the extent to which you've been compliant. And the other thing that I should mention is that there's a renewed focus on industry codes of practice. Now, an industry code, there is some debate going on in the industry about what exactly is an industry code of practice and how do they work. If you go to the NHVR website, that's the National Heavy Vehicle Regulator website, there's quite a lot of information, quite a lot of good information on there about industry codes of conduct. So I think as part of a compliance piece and thinking about what you might do in the next sort of 12 to 18 months in respect of compliance, if you are in a particular industry and the electrical cables is probably an example of an industry that has I think had a code of conduct in the past, and possibly might want to think about dusting that off and seeing whether it's making sure that it's compliant and relevant for the changes that are coming down the pipe. So there's any number of industries, I suppose. There's the grain, agriculture, probably cotton, any number of retail, forestry, just to name a few, that could benefit, I think, from giving some thought. And I know the regulator is actually out promoting at various industry group gatherings and promoting that they think about putting together a code of conduct. So, any more questions?
Certainly. Let's kick this one off here from Frank. How do you actually measure the culture of a company?
Well, I guess what you would do is the starting point is having a policy, right? I mean, well, I think the starting point now is doing the risk analysis, is doing the risk assessment. Okay, there is this thing called chain of responsibility. We think we might be in the chain of responsibility. Can we do a risk analysis and work out, okay, we've got these trucks that bring goods or collect goods from our warehouses or whatever. So you run your risk analysis. Basis on that risk analysis, you should probably have a policy. You should have a corporate policy, very much like companies have safety policies. If you go to a lot of companies' websites, there will be a safety policy, a health and safety policy on the website. So you have that policy. The question then is whether that policy is just a dry document that nobody really pays any attention to, or whether it is actively complied with and people really believe in the existence of that. Now, how do you measure that? You probably measure that by, if I walked into someone's site and I saw signs on the wall, I would think, okay, well, they're taking this seriously. You know, often I'll go into people's business premises and there'll be safety signs on the wall. That shows that they're taking it, you know, that's at least a first step. Is there a mechanism within the organisation for dealing with incidents and near misses? So if people feel, and this comes back to the point I made about, you know, information, is there a number for someone to ring? If someone member of your staff feels that there's an incident or they've seen something which concerns them, is there someone for them to feed that back to? Is there and is that call then logged and followed up? So there's a number of ways that I think you can measure the culture of a company.
That's great. Good answer. Thanks for that, Geoff. Got a question here from Chris. I think it's just drawing on a previous one. If I order a fridge from Bing Lee and it gets delivered by a heavy vehicle, I am part of the chain of responsibility. How far do you go with it?
Yeah, look, that's a very good question. I suppose that then comes back to your due diligence obligations. I would like to think that as the person who has ordered a fridge from Bing Lee, the regulator might not put you too high on his list of enforcement. But look, I take the point. Actually, well, I suppose if you've, I guess the question is, just looking here at the definition of business practices. Business practices of a person means the person's practices in running a business associated with the use of a heavy vehicle on a road. Not sure that ordering a fridge from Bing Lee means that you are running a business associated with the use of a heavy vehicle on a road. Going back to the electrical cable question earlier on, maybe that's even becoming slightly line ball, but you know, if you rely on, you know, if you're ordering deliveries at various sites several days a week, it's a much closer link, I suppose, to the chain of responsibility than the guy ordering from Bing Lee. Great.
We've got two more questions here, then we'll move on because we're coming towards the end. I know we've got another 4 slides to go. This one's from Greg, will the regulators investigate transport users like retailers for COR compliance even if an incident has not occurred?
My understanding is that, look, without getting sidetracked, the way that New South Wales has done it, obviously there's a lot in the chain of responsibility, right? It means that thousands of companies around Australia have compliance obligations, and it's not possible for the regulators to audit every business in Australia. They just don't have the manpower to do any of that. So what they've done in New South Wales is they've responded to acute incidents. So if a truck runs off the road and kills someone, they will, or if there is, you know, they'll deal with acute incidents of speeding or fatigue or whatever. In the background, running sort of in parallel to that, they have targeted, if you like, industry sectors. So for example, I know they targeted waste management businesses in the last sort of 12 months. So they will go into, and I know they targeted grain companies a couple of years ago now. So look, they will of their own volition go in and audit compliance. I know that both Coles and Woolworths, for example, may not be perfect, but they do have quite a strong focus on compliance. So they, I don't know this for a fact, but I suspect that they would be in reasonably regular contact with the regulators about their level of compliance and compliance systems.
Excellent, thanks for that. And last question here before we move on is from Ash. We often get owner drivers knocking on our door to work with us directly without the carrier in the middle. What's the risk for us in such a case? Are we considered a carrier?
Oh, Ash is Ash the freight broker?
I believe so, yes.
Look, what I have, and I'll try and answer this quickly because we are running out of time. People often have a primary carrier that they use. If that carrier can't do the business for them, they have a secondary carrier. And if they can't help because it's a job at an odd hour in an odd place, they might just pick up the phone and get anyone that can do it. It's that third level of people that I think pose the greatest risk of danger, because you don't know them that well, they don't know you that well, they don't understand what you don't really know their attitude towards compliance. Whereas the people that you deal with on a more regular basis, you do understand that they understand what the chain of responsibility is, and also there's a relationship there. So they don't want to stuff you around, you don't want to stuff them around. So it really is in that third tier, I think, where the danger lies. And I appreciate that you can't not use these people, or you can't not give them business if you've got really no other option. But there is a risk, and I think that was the question. Is there a risk? Then yes, I think that's where there is a risk.
And just to say, I think that was a great answer, Geoff, and Ash agreed and said many thanks.
Thank you, Ash. Then just sort of moving on to the final slides, because I know we're running out of time pretty quickly. So with container weight declarations, penalties are unchanged. The new obligation, each consignor or packer of the goods must ensure, so far as is reasonably practicable, that the weight of the container does not exceed the maximum gross weight marked. Keeping relevant documentation, keep it, if I can summarise that slide. And just finally, I think, oh no, I've got a couple of, two more slides to go. And this is an example of the due diligence activity that actually comes from the explanatory memorandum to the new Act. And this is sort of consistent with what I've been saying all the way along. You've really got to develop a safety management plan. You've got to perform that risk analysis that I've mentioned. Where do we come in contact with the chain of responsibility, and how are we going to manage those responsibilities? Make information readily available. So that's something I haven't really spoken about, and it comes back to the question that was asked about how do you describe or measure a company's culture. Training isn't going to be an important part of that as well. So yes, putting up signs on the walls, that's important. But those who are at the pointy end, so people that work in distribution centres, for example, who deal with truck drivers on a hourly basis, there should be some training for them so that they understand. Schedulers obviously have quite specific obligations in and around speeding. So make sure that you don't give a driver a book of business for the day that is going to mean that he's going to have to speed in order to make the various calls that he's been required to make. So yeah, training is important. Make appropriate resources and processes available to minimise risks in relation to the maintenance of vehicles. I spoke a little bit about that earlier on. And establish processes for considering and responding to information about incidents, hazards and risks. So I mean, I use the word whistleblower. I mean, make sure that you do have somewhere for people to go if they want to make an anonymous complaint, or not an anonymous complaint, but they want to make a comment or alert you as to something that might be going on that you need to know about. And then finally, what else can I do? Attain specific advice, not necessarily from a lawyer, but there are plenty of consultants out there who are providing advice now in relation to chain of responsibility and helping people develop compliance policies. Obviously, review your own policies and procedures. Are they going to minimise or eliminate the risks that have been thrown up by your risk assessment? Review all contracts with drivers and transport operators. Do they incentivise or require breaches? And consider tying payment incentive to HVNL compliance. So this was actually something that was raised by a judge in a case a couple of years ago. Maybe you could refuse to pay, he thought, an operator who was non-compliant with the chain of responsibility. I don't know how well that would go down, but that's what a judge thought. So look, that's all I really had to say. I know we've only got 4 minutes by my count to go, and I think we do finish, unfortunately, promptly at 3. I'm happy to take questions in the time that remains, and then I think, Jerome, people can still fire questions to you and you can pass them on to me. Is that right?
That's exactly right, and we certainly welcome them.
So are there any other questions in the last couple of minutes before we wrap?
Yes, I've got a good one here. One around the container mass. So you mentioned the slide a bit further back around container. How does that relate to the issues of containers coming from ports being put on trucks? So what can a driver do in that case? That is an interesting question. What can a driver do? A driver can only really, I suppose, establish to the extent that he can that the weight of the container is within the weight that he is authorised to load. If he's told that it is, and he's produced, and some evidence is produced. Sorry, where is that slide? There it is. If some evidence is produced, then I think that's really all he can be expected to do. There's another issue which relates to how well the goods are secured within the container. Now that's another really difficult one, and there's nothing I think that the driver can do to ascertain whether the goods in the container that's being loaded onto his vehicle are properly secured. Now there will be, there are chain of responsibility ramifications for that if it turns out that the goods aren't secured in that container, even if they've been packed in Vietnam, for example, by someone who doesn't know anything about the chain of responsibility. So look, that's another important piece behind all of this that people will need to, I think about. So yeah, I mean, if you're in a business that imports products from overseas, you do have an obligation to make sure that whoever's packing those containers, wherever they're packing them, is aware of the requirements for container packing in Australia. Excellent. I think that's all. Thank you, Geoff. I just want to say, excellent presentation, fantastic answer to the questions. So thank you very much for your time today, Geoff.
That's my pleasure. Thank you, everyone, for dialing in, and thank you, Jerome and Rosemary, for putting it on.
Thank you so much. And Geoff, did you want to just pop past to the last 2 slides so that we can just have a quick squeeze at...
I totally can. So there we are.
Yes, and there's your contact details, which is awesome.
There's my mug. And then the last slide is that one, the next event.
Yes, we've got the next event, haven't we, Jerome?
We do indeed. So looking forward to ANCAP presenting, talking about 5-star cars. So probably a bit of a different audience to those who we have online at the moment.
Interesting. And Geoff, just one last click to the last slide, which is about our conference. We would like to draw our audience attention to the exciting event of the conference that's coming up on the 28th Australian Road Research Board International Conference in 2018, and it will be held in Brisbane next April. And the theme is Next Generation Connectivity. So that's going to be awesome, isn't it, Jerome?
Of course it will, Rosemary.
And thank you to our audience. We'd love you to fill out the survey so that we can find out what you like and continually improve. Thanks so much, Geoff and Jerome.
And thank you, everyone.
Thank you, everyone.